May it please the Court. My name is Brent Steinberg, and it's my privilege to represent the plaintiff, Randy Willoughby. Your Honors, this Court should affirm because the trial court properly denied defendant's motion for set-off. First of all, as Your Honors alluded to, in the trial court, the defendant never argued that 768-041 entitled them to a set-off, so that issue hasn't been preserved. But even if it was preserved, under this Court's precedent, it doesn't apply because defendant and 21st Century, the uninsured motorist carrier, were not jointly liable for the same damages. And defendant's also not entitled to a set-off under 768-76, which is the collateral source statute. Quite simply, the uninsured motorist bad faith claim settlement doesn't qualify as a collateral source, and we briefed that fully. I won't get into that issue unless one of Your Honors has a question on it. So let me first address this preservation issue, and there's really two separate preservation issues here. The first is, as we said, that the defendant never argued that they were entitled to a set-off under 041 in the trial court. There's no question that they asked for a set-off, but they only ever characterized it as asking for a set-off because it was a collateral source. And that's kind of like saying that someone objects to evidence coming in because it's hearsay, and later they want to argue that it was inadmissible for a different reason under 9403. All the courts would say, yes, you asked for the right relief, the ultimate relief of keeping the evidence out, but the hearsay objection doesn't preserve the 9403 objection. That's essentially the situation that we have here. They didn't just fail to cite the correct statute, they never made the argument at all that there was a release that was delivered in partial satisfaction of the damages sued for. So they never made the argument until they got to the Second District Court of Appeals in the initial brief. Now, the second preservation issue is in the plain language of the text itself, in 768-041, subsection 2. As Your Honors alluded to, looking at that language, it says, at trial. At trial, if the defendant shows that shows the court, the statute says, that if they show the court that the plaintiff delivered a release to a person, then they get a partial satisfaction, and that it was in partial satisfaction the same damages sued for, then they get a set-off to that extent. Again, in the trial court, the defendant never argued that she was entitled to a set-off, making that argument. So the first time that they argue 041 is in the appellate court. That is not at trial. That is not never at the trial court. Of course, it's our appellate court's job to correct errors that trial courts make. And Your Honors alluded to the case law, and we cited several cases for the proposition that the trial court has to be given a fair and full opportunity to address the issue head on. How are we going to say that the trial court committed reversible error by failing to grant a set-off under 768-041 when the defense never asked the trial court to do that? So in our view, the issue has not been preserved. There's no need for you to get to the merits on 041. If you do want to get to the merits, we still prevail. And I want to clarify one thing. There was some discussion about the joint tortfeasor, and certainly the cases that this court has previously talked about was in the context of joint tortfeasors. But I think what's more important than even joint tortfeasors is whether or not there's joint liability. Now, of course, if they're joint tortfeasors, they would be jointly liable for the same damages. But I acknowledge in the Grobman situation, where you've got a vicariously liable party, it would make sense to apply the set-off even if they're not technically joint tortfeasors. For instance, if you have an employer who settles a claim, the employee, assuming it was vicarious liability, would get a set-off if the defense makes the requisite showing under the statute. So the court's focus in all of those cases is really, has there been joint liability for the same damages? Before we get more into the weeds on that.
Well, the precise language is may be liable for the same tort or death, right?
Under subsection 1, Your Honor?
Yes.
Yes. That's correct. And in the vicarious liability situation, which this is not a vicarious liability situation, we've got two separate silos here. We've got an uninsured motorist carrier on one side and a tortfeasor on the other. It's not vicarious liability, but when you're in the same silo, it would make sense that the employer is vicariously liable for the same tort or death as the employee who caused it. And that's why in Grobman there was a set-off, which is a DCA case. But stepping back, let's just think about what it is that they're asking for. And I want you to assume that we're not talking about a $30 million verdict. Say it was $3 million, and the plaintiff had already settled their uninsured motorist bad faith claim for $4 million. In that situation, would the defendant get a set-off for the entire amount and be able to tax costs against the plaintiff and perhaps even recover attorney's fees just because there was a separate settlement with an uninsured motorist carrier for $4 million when they in fact caused $3 million of damages? That wouldn't seem fair and equitable. It would be a massive windfall to the defendant in that situation. Well, that's essentially the situation we have here.
You know, I understand what you're saying, but on the other hand, what's happening in the claim against the uninsured motorist carrier is obviously in some sense derivative of what has happened in the context of the case against by the plaintiff against a tortfeasor. And this is not really an issue here, but let me ask you, help me understand the rationale behind the legislative policy that awards that authorizes a bad faith claim against uninsured motorists that goes beyond the actual amount of any kind of damages that were attributable to the failure to pay the uninsured motorist claim.
Sure.
I mean, it's very different than an ordinary uninsured. Bad faith claim where there's the risk because the carrier failed to settle that the policyholder is going to be exposed to damages that exceed the amount of the coverage. But I'm trying to understand how that gets translated over into the uninsured motorist context.
Sure, and certainly to some extent I agree with Your Honor that the damages that are recoverable are derivative, but it is a separate claim. But to your question, and this is outside the briefs, but let me just to try to address your question. So, under the common law since 1938, we had third-party bad faith claims, and we never had first-party bad faith claims. That didn't come until 1982 when the legislature passed the 624-155. And there was a Supreme Court case called McLeod, which said essentially that the damages that were recoverable in that case, if the uninsured motorist carrier acted in bad faith, were only essentially the consequential damages. And it was a couple years after McLeod, maybe even the next year, the legislature essentially overrode McLeod by passing subsection 10 of the uninsured motorist statute, which says that the damages shall include not only the damages caused by the uninsured motorist carrier and their failure to settle, but also the damages caused by the tortfeasor. And this body has said that that was in effect a penalty. It was most recently in the Fridman decision said that it was a penalty for the wrongful failure to settle. So that was the legislative's intent behind that. It was essentially to override the McLeod decision and to make sure that there were some teeth, because sometimes there aren't any consequential damages caused by the bad faith failure to settle, but the legislature wanted the UM carrier to pay the damages that were caused if it is found that they violated 624-155-1B1 by failing to attempt to settle in good faith. And here there was we alleged a wrongful denial of coverage, and that was what was the genesis of that claim. But back to the 041 argument, so the focus has always been, and it actually started in the Delvin decision, and then went on in Reimer and Wells and Gowdy and D'Angelo. And all of 5 of those cases, the court was always focused on, was there joint liability for the same damages? Essentially, that is what the court interpreted impartial satisfaction of the damages sued for means, which makes sense. If it's going to be a partial satisfaction, given there had to be some sort of joint liability there, and there had to be the same damages. And I apologize, Your Honor. It seemed from the briefing at least that the defense agreed with me on that point, and that our dispute was essentially over whether there was joint liability and whether or not the damages are the same. But back to Justice Kennedy, your question about the legislative intent, the UM bad faith statutes make clear that the UM carrier shouldn't get a set-off for an amount paid by the underinsured tortfeasor. We have 155 1B1 that says when they fail to attempt to settle in good faith that they'll be liable for the damages provided by statute. Subsection 4 says that they shall be liable for the damages plus fees and costs. And then subsection 10, as we said, says that those damages shall include the total amount of the damages, whether caused by the tortfeasor or the carrier. And if we look at the shalls, the carrier shall be liable for those damages, and we understand the penal purpose behind it, then it would make sense that the carrier wouldn't get to offset its own liability in bad faith for some amount paid by the tortfeasor. And that brings us squarely within this court's Wells decision, because that would mean that they were only severally liable. They weren't jointly and severally liable. They were only severally liable for the damages, meaning that 768-041 should not apply. The damages, as Your Honor alluded to, were not identical either. They're not the same damages. They're two, one is a statutory penalty, and it is true that when you're calculating the amount of that penalty, you do understand and consider the underlying personal injury damages. But there are other buckets of damages. There's attorney's fees and costs, pre and post judgment interest, consequential damages, perhaps even punitive damages. And Mrs. Ellison would never be liable for any of those. So the damages aren't the same either. And we cited multiple cases which held that a set-off under 041 is not appropriate when the damages, although maybe overlapping, were not coextensive. The damages have to be identical. So if they're overlapping but they're not the same damages, then they don't get a set-off. Now, if you disagree with me both on the points of joint liability and the damages being the same, then we get to the apportionment question and the Dionese case. And first of all, just to clarify, excuse me, Dionese was a case against joint tortfeasors. So there was no question that there was joint liability, and which is unlike the situation where the uninsured motorist carrier should never be jointly liable with the tortfeasor. But Dionese is also distinguishable. It was a case about two plaintiffs. There was a husband and a wife. The wife had a claim for her injuries, and the husband had a consortium claim. And what happened there is they settled with one defendant, and then they allegedly made a secret agreement among themselves on how to divvy up the money to maximize their recovery from the remaining defendant at trial. And the court says that that's not binding. The settling defendant wasn't part of that agreement, and the secret allocation shouldn't be binding on the non-settling party, and that wouldn't be fair. So what the court did there is they allocated the award proportionally, meaning that, for instance, if the wife had $90,000 in damages and the husband had 10, then the first settlement should have also been split 90-10. The Wells decision, much later, the court said it would invite collusion to allow the settling parties to control the allocation between different elements of damages. That is more akin to the situation we have here. And I'm paraphrasing what the court said in Wells, but the court said that the plaintiff would seek to maximize the amount of their settlement, apportioned to the claim where there's no joint liability, and it would make no difference to the settling defendant who's getting out of the case, so they would be more likely to be amenable to that allocation that's proposed. And perhaps they would even be able to settle the case or save some money on the settlement if they agreed to the plaintiff's proposed allocation. And all that makes sense, and that's why the allocation isn't binding.
It would be a sham allocation.
It could be. It could be. Let's play that out. Let's say that I had an agreement with 21st Century that all $4 million would be allocated to attorney's fees, interest, and punitive damages, none of which is recoverable from Ms. Ellison, so there'd never be joint liability for that. Why would it be fair to say that Ms. Ellison would be bound to that allocation, even if it appeared on the face of the settlement agreement itself? It wouldn't be fair. She didn't have the opportunity to object. She wasn't a participant in that settlement agreement. So if the allocation agreement, if we had one, wouldn't be binding on Ms. Ellison, then why should she get an automatic set-off for the full amount just because we didn't have an allocation agreement? That doesn't make sense. Particularly if you look back at the statutory text, it says at trial, if any defendant shows the court, the burden is on the defendant there. I don't, as a plaintiff, have to do anything. the defendant has to make the showing. They have to ask the trial judge or perhaps even the jury in a bifurcated proceeding to determine the extent of the overlap. If, in fact, there was joint liability, and if you get past the joint liability and determine that at least some of the damages were the same, that is what the defendant's burden was. And they simply didn't meet that burden because they never even asked for a set-off under 768-041 in the trial court. So they didn't meet their burden of proving a duplication, meaning that the trial court was entirely correct to deny set-off. On 768-76, if the court is applying the supremacy of the text principles, it is looking at the text, what is written on the page. It is not accepting the defendant's invitation to try to apply some broader intent to prevent double recoveries. Of course, the statutes don't say anytime there's a double recovery that the defendant gets a set-off. We have to apply the text as it's written. And the legislator hasn't defined a collateral source to cover an uninsured motorist bad faith settlement. They claim in the briefs under three separate provisions. First is subsection 2A2, where they say that certain types of insurance benefits are collateral sources. Not all insurance benefits, just certain types. And the defendant argues that 2A2 applies because the settlement was derived from the plaintiff's uninsured motorist policy. Well, the word derived doesn't appear in the statute. The question isn't whether the settlement was derived from an insurance benefit, which is recoverable. The question is whether or not the payment was an insurance benefit. And this, by definition, is not an insurance benefit. It is a statutory penalty over and above what they owed under the policy. It is extra contractual damages. So 2A2 does not apply. 2A3 is about payments to pay medical service or agreement to pay medical services. And 2A4 is an agreement to provide disability benefits. And our settlement with 21st Century was neither of those. 21st Century didn't agree to pay medical benefits. They didn't agree to pay disability benefits. They would never be liable for essentially health insurance or disability insurance. Now, it's true that the plaintiff could use some of that money that he recovered to pay his own medical expenses, or perhaps he could have paid his own or compensated him for his lost wages. But 21st Century didn't agree to pay that, and there's no reading of the text where you can say that an uninsured motorist bad faith settlement qualifies as a collateral source.
Is your argument on that, though, to defeat there's a sense in which part of the argument is this is just completely kind of categorically talking about different things, but to the extent that you're literally that you're responding to this kind of literal argument that it was an agreement and it was, the damages included medical expenses. Is it just the fact that the settlement agreement itself doesn't say we're going to pay you $4 million, including $1 million for past medicals? I mean, would that fit it within the statute, or how much of the argument hinges on the absence of those specific words in the agreement?
I think it's important to remember the claim being settled, not so much dictated by what the settlement agreement said, but the claim was for uninsured motorist benefits and uninsured motorist bad faith. And the UN benefits aren't recoverable, and that's not even an issue which is before the court, but there's a contractual right of subrogation in a UN policy, which under subsection 1 means that they don't get a set-off because of the subrogation right, even if it did qualify as a collateral source. So we're talking about the UN bad faith damages, and the payment was just not a reimbursement or a payment of medical expenses. And just to clarify, when we say that something is on account of a personal physical injury, which is put in there for tax purposes, that is not the same thing as saying it is a payment of a medical expense. It was a settlement of a disputed claim for violation of 624, 155, 1B1. So if you had that type of broad reading, then you could say that any settlement could, if it was later used to pay medical expenses, would qualify as a collateral source. And of course, our common law collateral source rule still exists, and the statute overrides the common law, and the courts always have said that we will not read the statute to override the common law unless that change has been effected with clarity. And this does not clearly override the collateral source common law rule in this situation. So
You can have 30 seconds to finish up.
well, for those reasons, I guess, Your Honors, we'd ask that you'd affirm, unless one of you have additional questions, I'd be happy to answer. Okay. Thank you very much.